You're 71 years old. You worked for 40 years. You scrimped. You sacrificed. And 22 months ago, you made that final mortgage payment. You actually held the paper in your hands. You framed it. It hangs in your hallway right now. That house is yours. No bank, no lien, no debt, just yours. And then your doctor uses a word you weren't expecting, a word that changes everything. He says you need long-term care. He says you probably can't live alone anymore. You think, fine, I'll use Medicaid. I've paid into this system my whole life. And then a caseworker hands you a document. And buried inside that document, on page 4, in language that reads like a legal contract nobody explained to you, is a program called Estate Recovery. And what you're about to find out is this: Medicaid can pay for your care, and then after you're gone, it can come back for your house, the one you paid off, the one with your name on the deed, the one you were planning to leave to your children. Most people don't know this exists, and by the time they find out, it's already too late to do anything about it. Stay with me, because what I'm going to walk you through today could be the most important thing you watch this year. Here is the trap in plain terms. Medicaid is a needs-based program. To qualify, you generally can't have much in the way of assets, but there's one major exception: your primary home. Under federal rules, your house is considered an exempt asset when you apply. Medicaid won't count it against you. You can qualify for care, move into a nursing facility, and your home sits there, off the ledger, untouched. But here's what the system doesn't advertise. That exemption only lasts while you're alive. The moment you pass away, a federal program called Medicaid Estate Recovery kicks in. And in most states, the government has the legal right to file a claim against your estate, including your home, to recover every dollar Medicaid spent on your care. We're not talking about a small number. We're talking about nursing home costs that routinely run $8,000, $9,000, $10,000 a month. We're talking about a 2-year stay costing over $200,000. We're talking about a claim that can arrive at your children's doorstep while they're still grieving, demanding the house before they can even think about keeping it. This is legal. This is happening, and it is happening to families who had no idea the clock was ticking. Why does this happen? And why don't more people know about it? Because the rule was designed to be invisible until it's too late. Here's the background. In 1993, Congress passed a law requiring every state to have a Medicaid estate recovery program. States were required to pursue repayment for nursing home and long-term care costs from the estates of deceased Medicaid recipients age 55 and older. The justification was simple. Medicaid is meant for people without resources. If someone had a home they weren't using because they were in a care facility, the state argued it was reasonable to recover those costs from that asset after death. States were given flexibility in how aggressively they pursue recovery. Some states only go after what passes through probate. Others have expanded their reach to claim assets that don't even go through probate, including certain trusts, jointly held property, and even life estates. The law is quiet about this. The application paperwork mentions it, but it's buried, and most people who sign Medicaid applications are not reading fine print at one of the most stressful moments of their lives. So the home gets protected during life, and it gets targeted after death. And in between, nobody warns the family. Now let's go deeper, because there are 3 layers to this trap, and each one is worse than the last. The first layer is the recovery claim itself. When you pass away as a Medicaid recipient, your state's recovery program will look at what's in your estate. In most states, that means anything that goes through probate. Your paid-off home, if it's solely in your name and passes through your will, is fair game. The state files a claim. Your heirs have limited options. They can pay the claim, negotiate in rare hardship circumstances, or surrender the property. In many cases, the home must be sold to satisfy the debt. Let that settle in. You paid off your house. You left it to your kids in your will, and the state can step in and take it. Not because your kids did anything wrong, but because Medicaid spent money on your care and they want it back. The second layer is spousal exposure. Let's say you're married. Your spouse is still living in the home when you pass. Here's the good news. Most states will not pursue recovery while your surviving spouse is still alive and living in that home. That protection is real, but the clock starts the moment your spouse passes away. Now, the home belongs to the estate of the last surviving spouse, And if Medicaid was used at any point by either of you, the state can now move on that property. Your children, who may have expected to inherit that house, receive a claim instead. The home their parents spent 40 years paying off becomes a liability. This is the moment families fall apart over something no one warned them about. The third layer is the expansion states. Not every state plays by the same rules. While federal law requires recovery only through probate, many states have expanded their programs to reach beyond probate entirely. These are called expanded estate recovery states. In these states, Medicaid can pursue assets held in certain living trusts, assets with rights of survivorship, and life estates, legal arrangements that people often set up specifically to avoid probate. People do this in good faith. They set up a living trust. They think the house is protected, and then they find out their state's recovery program reaches right through that structure. The tool you use to protect your family becomes the very thing the state looks through. Now let me show you what this looks like in real numbers. Side by side, meet Robert and Patricia, both 74 years old. Their home is worth $380,000. It's paid off. They have modest retirement savings, about $90,000 combined. They live in a state with an expanded estate recovery program. Robert develops dementia. He requires full-time nursing home care at $9,000 a month. After spending down their savings to qualify for Medicaid, Robert receives benefits for 26 months before he passes. Medicaid has spent roughly $234,000 on his care. Patricia continues living in the home. She is protected while she's alive. But 3 years later, Patricia passes as well. Their daughter Karen is the sole heir. She expects to inherit the house. Instead, within months of her mother's death, she receives a notice from the state's Medicaid recovery program. They are claiming $234,000 against the estate, the full cost of her father's care. The house is worth $380,000. After legal fees and the recovery claim, Karen receives approximately $130,000, less than half the value of the home her parents spent their lives building. Now let's look at the family next door. Same ages, same house value, same financial profile. But 5 years earlier, they sat down with an elder law attorney. They transferred the home into an irrevocable Medicaid Asset Protection Trust, sometimes called a MAPT. They retained the right to live in the home for the rest of their lives. But the home legally moved out of their estate. When this family's husband required nursing home care 3 years later, they waited past the 5-year lookback period, the time Medicaid requires between asset transfers and benefit eligibility. The trust had been set up in time. The home was protected. Medicaid covered the care. And when both parents passed, their daughter inherited the full value of the home with no recovery claim. Same scenario, completely different outcome. The only difference was planning and timing. So what do? What does protection actually look like? First, find out what state you're in and how aggressive their recovery program is. Some states are minimal, others are expansive. This single fact changes your strategy entirely. You can search your state's Medicaid Estate Recovery policy or ask an elder law attorney directly. Do not assume you know until you've confirmed it. Second, if your home is in your name alone and you have no plan in place, talk to a qualified elder law attorney about an irrevocable Medicaid Asset Protection Trust. This is not a DIY project. The timing matters enormously. The 5-year look-back rule means you need to act before a care need arises. If you wait until a diagnosis, the window may already be closing. Third, if you are already receiving Medicaid or anticipate applying in the next few years, ask specifically about hardship waivers and recovery exemptions. Some states have provisions for cases where a dependent child was living in the home or where recovery would cause undue hardship. These protections are narrow, but they exist, and your family should know about them. Fourth, do not assume a living trust protects you from Medicaid recovery. In many states, it does not. A revocable living trust, which is the most common kind, offers zero protection from estate recovery. The home is still considered part of your estate for recovery purposes. If someone told you your trust protects your house from Medicaid, get a second opinion. Fifth, if you are the surviving spouse and your spouse received Medicaid, understand that the countdown begins when you pass. Make sure your own estate plan addresses what happens to the house at that point. Do not leave it to chance or assume your children will figure it out. Sixth, if you are in your late 50s or 60s and in good health, this is the best possible time to act. Not because anything is wrong now, but because the 5-year window requires you to plan before the need arrives. Every year you wait is a year closer to the line where planning becomes impossible. Here is what I want you to remember. A paid-off home feels like the finish line, and in so many ways, it is. It represents a lifetime of discipline. It represents security, legacy, and love. It is, for most families in this country, the single largest asset they will ever own. But Medicaid Estate Recovery treats that home as a debt waiting to be collected, not while you're alive, not while your spouse is alive. But the moment the last survivor passes, the state steps in, quietly, legally, and powerfully, and takes its share of something you spent a lifetime building. This is not a theoretical risk. This is a documented program operating in every state in this country. Families are losing inherited homes right now. Adult children are opening letters from state agencies while they're still picking out headstones, and the overwhelming majority of them had no idea this was coming. The difference between the family that keeps the home and the family that loses it is almost always just one thing someone told them in time. You now know. If you have a parent, a sibling, a friend who owns their home and doesn't have an elder law plan in place, please send them this video before another week goes by. Save it. Come back to it. The steps I laid out today are a starting point, not a finish line. Subscribe for more warnings like this one, because the rules governing retirement, long-term care, and inheritance are complicated, they're changing, and most people are walking into them completely unprepared. You don't have to be one of them.